All right. Welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. The series is hosted by the Department of Psychiatry and Behavioral Sciences at the University of New Mexico and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Brovko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. Next week, we have Dr. Mike Vitacco presenting the basics of conducting conditional release evaluations. For our talk today, ask your questions in the Q&A anytime you feel comfortable. Just remember, we're not going to get to them until the end. For those of you who want CEs, you're on a tight schedule. You do have to stay for the full hour today, but you don't have to stay longer than that. We'll try and let you know when the hour has passed, but we will be staying on longer to address questions. For those of you who are here for CMEs, the sign-in is in the chat now. For the mental health or APA CEs, usually we post the link in the chat. We're actually going to be emailing that out to you all instead, and we're hoping that that will help us with the server issues that we've been having, over the last month or so. So you won't be seeing the link in the chat today. We will email it out to you guys right away, or pretty close to after the talk today. So if an hour or so has passed and you don't have it, let us know. The recording and the PowerPoint will be uploaded in about a week. I think that's it for announcements. So I will go ahead and introduce to you our speaker for today, Dr. Virginia Barber Rioja. Dr. Barber Rioja is currently the co-chief of service for the group that oversees mental health treatment and all court-ordered forensic evaluations in the New York City jail system. She's also an adjunct professor in the Department of Psychology for New York University, where she teaches in the graduate program. She maintains a forensic practice involving criminal court cases, and she's the first author of the book, Mental Health Evaluations in Immigration Court, a guide for mental health and legal professionals, which will be published this summer. Dr. Barber Rioja, thank you so much for being willing to present today. We're grateful for your time and expertise, and I'm honored to welcome you. I'm now going to turn it over to you.
Thank you. Thank you so much for the invitation. It's really an honor to be able to participate in the series. And I'm particularly excited to be able to talk about forensic mental health assessment in immigration court. I think this is an area that it's now actually in recent years starting to receive a lot of attention from the psych and law literature. And I think that is exciting because it's an area where we need a lot more research and we need a lot more people who are, qualified to be doing work on. And so what I am planning on doing today, this is just giving you an overview of this area of forensic assessment. And what I will do is start with, since I don't know how many people who are attending have ever done any work in immigration court, I am going to start with providing some information about the legal context of immigration court. I'm obviously not a lawyer, but just some basics about the context that I think everyone who is planning on doing work in this area should have. And I also think in general, although we hear a lot about immigration, especially from politicians, but immigration court and the process of immigration court and how does it work is mostly sort of unknown to definitely to the general public, but also sometimes specifically to people who are even doing the work in this area. So I'll do a little bit of that, and then I'll talk about what is the purpose or the goals of forensic mental health assessment in immigration court. What are the different types of evaluations that mental health professionals can get involved when doing work in immigration court? I'm going to highlight some that are sort of the most common. I've picked 3 and then highlight what are the psycholegal issues that are connected to those types of evaluations. And then I will just point some areas that I think are important for, for future research. So I'll start with that. Okay. So you're probably all familiar with these numbers, but approximately 11 million individuals who live in the United States lack US documentation. And this can happen in really one of two ways. It's mostly people who enter the country illegally without proper documentation to start with, but it also includes individuals who enter the country legally with some type of visa, but then stayed beyond the expiration of their visa and then became undocumented or without proper documentation. And this is 3.3% of the US population. So it's a big chunk, and these numbers keep growing. The vast majority of people who are undocumented in the United States are individuals who have migrated from Central America, from specifically from Mexico and other Central American countries. So although there are many different languages that are spoken in immigration courts, Spanish is the most common. And then I also want to mention that even individuals who may actually have a documented status. So for example, individuals with a permanent resident or a green card might face deportation if they commit certain crimes. So anyone who lacks valid immigration status, of course, can face deportation if they commit a crime, but also people who are here legally, like individuals with a green card, can face deportation if they have a conviction, even if the conviction took place many, many years ago. Many of the cases that I do are of individuals who've been in the country legally with a green card for 30 years, who are working, who have jobs, who have families here, and suddenly immigration picks up that they had a conviction 20 years ago. Maybe they did their time already. For the most part, they did their time already. Sometimes they didn't even have to do any time. And now they're facing deportation because of that. Most non-citizens have the right to a hearing, though, before being deported. So if the government finds out that you are in this country and you don't have proper documentation and they are going to deport you, you have the right to a hearing in front of a judge for the most part. And then non-citizens have different ways of avoiding deportation. And that's what it's sort of in the legal language they refer to as removal relief. They use the word removal interchangeably with deportation. And so there are different applications that people or legal courses of action that people can apply for to avoid removal or avoid deportation. And I also want to note these numbers. In 2018, there were about 434,000 removal proceedings that were initiated across the country. And this was a 41% increase from 2014. And these numbers, as I said, have continued to grow. So there are more and more people that are now in deportation proceedings. And this means that there are also more and more people that are in immigration detention. And immigration detention is also a form of detention that many people are very unfamiliar with. It is the only form of detention in the United States that can happen without the individual having the right to a defense counsel or an attorney. And in any given day, and these numbers are probably higher now, it is estimated, because it's very difficult to find the actual numbers, but it's estimated that there are about 34,000 immigrants detained in over 300 facilities. And I'll talk a little bit more about these later on. And also incredibly difficult to find good numbers on how many people who are incarcerated in immigration detention have a mental illness. This is, I think, really an area of research that, it's to be explored. But it is estimated, Human Rights Watch estimates that about 15% have a mental illness. In fact, the New York Times called immigration detention the fastest growing form of incarceration in 2012. And as I said, it has continued to grow from there. In immigration court, applicants are referred to as respondents. Immigration courts are operated by the Executive Office of Immigration Review, which is a component of the Department of Justice. So again, this is just a completely separate, different form of sort of court functioning. Immigration judges hear cases, and then administrative appeals are decided by the EOIR's Board of Immigration Appeals, the BIA. The government is represented in immigration court by attorneys from Immigration and Customs Enforcement. So ICE attorneys are sort of the equivalent to the prosecutor in criminal court, and they are under the Department of Homeland Security. And the job of the ICE attorneys is to provide immigration judges with grounds for removal. So it is an adversarial system, which is also something that sometimes people don't realize. Then the judge or the EOIR grants relief from removal. The individual is issued evidence of his or her new status if they are actually granted removal through a visa or through asylum, etc. And then have to work with the US Citizenship and Immigration Services to then process all of the paperwork, which is a separate agency within DHS. Sometimes there are some visas, for example, the U visa, which I'll mention later, that is actually processed entirely by USCIS. So that when in immigration court, when you're really talking about the legal decision maker, for the most part, that's going to be an immigration judge, but sometimes it's a USCIS officer. So it's not always a judge that makes the ultimate decision. And part of the reason why I go through all of this, that it's just so confusing, is because I'm gonna go back to this when we talk about competency to proceed with immigration proceedings, because it is just such a complicated system that is constantly changing. And as you will learn, we typically ask immigrants to navigate this system without legal representation, which I think it's really relevant when we're talking about competency. I will say I myself have gone through having to apply for a green card, being denied a green card 3 times, having to almost leave the country because I was running out of time. And, you know, I'm an educated individual who's fluent in English with a Ph.D. and had to hire an attorney because I couldn't figure it out myself. So, you know, sometimes I think about that when I think about, you know, immigrants who might not have, do not speak the language, and might not have the level of education and do not have the means to afford an attorney. So that's sort of as an aside, but adding to the legal context, so DHS and the respondent or the respondent's attorney, if the immigrant has an attorney, present evidence, and then the immigration judge makes the final decision about removal, deportation. There are about 60 immigration courts nationwide with approximately 350 immigration judges. And this is, you know, it's just, again, because I find the system just so complicated, I have this diagram to sort of help understand these. So, you know, the judges fall under the Department of Justice, but the prosecutor, you know, the equivalent to the prosecutor or the government attorney is, they are under ICE, which is part of DHS, and then USCIS is also part of DHS, which processes sometimes in parallel some of these visas. So, going on with the legal context, immigration court is considered civil law. And therefore it's considered non-punitive. However, the reality is very different. In reality, many immigration law scholars actually believe and have referred to immigration court as a quasi-criminal court. And this is because individuals in immigration court are facing consequences that are as serious as the consequences that one faces in criminal court, including incarceration, right? You can be detained while you wait deportation proceedings. And then some people who are deported are literally facing death if they are being persecuted or tortured in their countries of origin, or if they have some mental illness that they are receiving treatment for here, but are unable to receive treatment for, or medical illnesses in their countries of origin. So the consequences of deportation and the consequences faced by individuals going through immigration court can be really serious. And it is a pretty adversarial system. And that's why many legal scholars refer to immigration court as quasi-criminal, even though in nature it is considered civil law. As you might know, respondents or immigrants are not guaranteed the same constitutional rights as in criminal court, including the Sixth Amendment right to the assistance of counsel. So even because it is civil court, they don't have that right. But again, as I said, it almost functions as criminal court. And so what this means is that we do know that especially for immigrants who are detained, if you don't have representation, in part because of the reasons I just mentioned about how complicated the system is, what that means is that most people are not successful in challenging deportation. So more than 90% of detained immigrants without representation are unsuccessful in challenging deportation. Your chances of being successful significantly increase if you have a lawyer, and there is some evidence started to come up that if you do have a mental health professional or an expert involved in the case, then your chances increase even further. I will say that there are some things that have improved recently. So one of them is the National Qualified Representative Program, which now provides free legal representation for, in some states, not all states, although it is expanding, for immigrants who have been found non-competent to proceed or for whom there are some concerns about their competency. And then in New York, actually, it's one of the few states where thanks to funding from different agencies and the city, nowadays, every immigrant who is detained, only detained immigrants who are facing deportation do have the right to legal representation. So some of the legal defender agencies that provide free legal representation in criminal court do have, a department for immigration court, which is great. And it's through, it is through them that I'm getting most of the cases that I do in my independent practice these days. Just very quickly about detention, I don't want to spend a lot of time on this, but immigration detention is the practice of holding in custody people or families who are subject to immigration control, either while they're waiting permission to enter. So this can happen right when you cross the border, right? Like right there, you can be detained. And even if you've requested asylum, as you wait for a decision to be made, you can be detained. Or even if you are already, you already crossed and you were undocumented and you've been living in the country for years, at any point, if the government finds out that you are undocumented, you potentially can face deportation. Detention. And detention in the immigration system does not have a rehabilitative purpose as it does in the criminal system. It has only two purposes. One is to prevent non-citizens from absconding deportation, and the second one is to protect the public. And that second one is very tricky because I'm not going to be covering risk assessment here, but it is, at least in conversations I'm having with attorneys and in my independent practice, coming up more and more, because immigration judges have very little education about basic things like the relationship between mental illness and risk. And they overestimate the risk of people who have psychiatric disorders. So they're more likely, immigrants with mental illness are more likely to be detained as they wait for deportation proceedings. So risk assessment, it's now a common referral question in immigration court. And I also will say that there are different types of facilities. So some immigrants are detained in federal detention facilities that are managed by ICE, but there are also privately controlled correctional facilities. And then there are some state and municipal jails that subcontract bed space with ICE. And I also will say, I work in a jail setting, and one thing that it's really sort of mind-blowing about immigration detention is that it is this sort of unknown, there is such a gap in knowledge about what type of mental health services people are receiving in immigration detention, what type of reentry services people are receiving in immigration detention. And the only information that we have comes out of lawsuits, of course. And I think there are more and more lawyers that are suing immigration detention because of high numbers of suicides and violence and poor reentry planning. And that's how we are starting to get more information. But there's like a huge gap in knowledge about the conditions of immigration detention, like how frequently solitary confinement or isolation is used in these detention facilities is another area where we have very limited knowledge. Very quickly, of course, this deserves more than one slide, but immigrants are at risk of experiencing mental health difficulties. I think this probably sounds pretty obvious, but many of them have experienced trauma in their countries of origins, which is the reason why they're escaping their or leaving their countries in the first place. If you've ever heard any immigrant tell you about their migration journey, you probably already realize how stressful, if not traumatizing, that can be. Sometimes they spend days walking and with their families, they're separated from their families. There's just so much adversity that takes place through that. And then once they make it to the United States, they face discrimination, they face language barriers, because they are undocumented, they don't have proper health insurance. And so they face a lot of adversity also once they arrive into the country. As I said before, it's estimated that 15% of those in detention have a mental illness. It's unclear how much that's serious mental illness versus any type of mental illness. Again, there's just no good surveys that have been conducted in immigration detention. I found one study in the UK that actually did do a screening for depression in immigrants who were detained and found that more than 50% screened positively for depression. And I think that given this and given the most strict, the really sort of strict immigration policies that were implemented by the Trump administration, but frankly, this has not gotten that much better during the current administration. There is, the APA is a quote from the APA, there is greater demand than ever for psychologists who can do this work. And I can attest to this, that, given the zero tolerance state in Mexico policies that Trump implemented, that, return people to Mexico or to their, even if they weren't from Mexico, right? Like someone from Honduras, for example, who was trying to cross the border, they returned people as they were waiting for their asylum decisions. They separated families. And so there were lots of lawyers who pro bono sort of rushed to the border to try to help individuals. And that came with also psychologists who were called to help with this task, especially for asylum seekers. And so there's really huge demand for psychological expertise in immigration court. Psychological evidence. So this is sort of where we really start. I've given you some background, and this is where we start really talking more about forensic mental health assessment, specifically in immigration court. Psychological evidence is crucial in many applications for removal relief. So these different types of applications that people can access to be able to remove deportation. I mean, I would say most of them, there is a piece of it within the law that incorporates or includes some psychological evidence, primarily evidence of trauma. And it is, as I said, crucial in many applications. Asylum is the most obvious one, but there is many others like hardship. Competency is not per se a removal relief application, but it's a psycholegal issue that comes up in immigration court, and that it's coming up more frequently now. Risk or dangerousness, as I mentioned to you before. So many different areas in which psychological evidence is crucial. And despite of that, the field of psych and law have really paid very little attention to this important area of forensic mental health assessment. In an article by Fromkin and Friedman already in 1995, they said that the legal and psychological communities have given little attention to forensic evaluations in immigration cases. I mean, things have certainly changed. There are now a couple of books that are really good that cover forensic assessment in immigration court. But it is starting to be part of, you see now they're starting to incorporate some chapters in psych and law books. But, for those of you who've studied psych and law, it has not been part of textbooks. I went to John Jay for my Ph.D., which was a forensic, very, very specialized forensic psychology program, and we never even touched immigration court as a type of forensic mental health assessment. So there is very limited empirical literature, although again, I'm seeing more and more, which is really satisfying. I also want to quickly say that working in this area requires different areas of expertise. And I think this is really important to say because in part because of the lack of literature and the lack of research, years ago, when I started doing this work 15 years ago, most of the people that I saw involved in this work were clinical psychologists who had absolutely no training in forensic psychology, and they were testifying in immigration court. And that was the vast majority of people, or sometimes even, social workers, counselors who were doing a good job, within their area of expertise, but were really neglecting to address the forensic issues that come up in immigration court, just like they come up in any other legal environment. And so working in this area requires expertise in forensic mental health assessment. It also requires expertise in multicultural psychology, right? Pretty much every single person that you're going to be working with is going to be from a different culture than your own. And so, so this is really crucial. It is very important to be knowledgeable about trauma and the psychological impact of persecution and torture, because that comes up very often in immigration court. And then you, just like when you work in criminal court, you need to have some working knowledge of the immigration law and then in immigration law context. And I mentioned neutrality here because I would say that a lot of people who, I don't know if a lot of people, but many people who get involved in immigration court work, probably more than in any other type of court environment, do this work pro bono. And I think this is great. I myself do some of this work pro bono, but I think that it's really important to remember that just like in any other area, you need to follow the specialty guidelines and the ethics code and aspire to be neutral and objective. And if you're doing the cases pro bono, you need to really sort of understand why you're doing the case pro bono and be able to defend that if you're testifying in court, so that it is not misinterpreted as, the judge might interpret that as the fact that you are biased in some sort of way, which has come up for me in immigration court. So having said that, there are different goals of forensic mental health assessment in immigration court. I'm only really going to focus on two here today because of the limited time that we have, but the main one is to provide evidentiary support for a fact or probability that must be found in order for an application to be granted, right? So for example, you are, the individual is applying for asylum, and so you are asked to provide, and part of the asylum, the eligibility for asylum involves evidence of persecution or fear of future persecution. And so you are asked to provide evidentiary support for that. We'll talk later about the different types of psycholegal issues that come up within this first item. Another part is balancing positive and negative equities. This is how they use it legally. And it's very similar to how you will do a mitigation evaluation in criminal court. And this is because, as I mentioned before, in immigration court, many people are facing deportation because they were convicted of crimes in the past. And there is also this legal term that comes up in a lot of different types of applications that is called good moral character, which I know sounds a little strange, but it's present in a lot of the immigration law, which means that you have to prove that the individual had good moral character. And that might involve contextualizing some crimes that they might have committed as being the result of mental illness or substance use, talk about personality, characteristics, etc. And then it is ultimately, a lot of immigration law is discretionary in that immigration judges have ultimate discretion on their decisions, even if you meet full criteria for it. And so they then, take into consideration the positive and the negative equities and make a final decision. Dangerousness risk, as I mentioned before, is another area that comes up when judges are making decisions about bond or detention for immigrants who are facing deportation. And then competency to proceed in immigration court, which is also an area that has recently started to receive, thankfully, more attention. And I'll talk a bit more about that later. So I'm just going to very quickly cover today some of the evidentiary support. So some of the applications that require psychological evidence as part of this first bullet point here, and what are the psycholegal issues involved. And I've picked the ones that I think come up most frequently, but there are several others that I'm just not going to be mentioning. And then I'm going to talk about competency. But I'm not going to talk about the sort of mitigation-like evaluations or the dangerousness risk. So these are the three types of applications that I've selected to cover very quickly here so that you can have a sense of what are the psycholegal issues that are involved in these types of evaluations. The first one is what sort of it's referred to as persecution-based relief. And it involves asylum, the Convention Against Torture, and actually a third one that is referred to as, I'm not going to talk about it, but there is a third one that is very similar to, it's called Withholding of Removal. It's very similar to asylum and CAT, so I'm not going to mention it. Then I'm going to talk very quickly about victimization-based reliefs, and these are applications to avoid deportation that are available to individuals who have been victims of crimes, of any crimes in general, and of human trafficking specifically, and also violence against women. And then hardship-based relief, which is for families that will face hardship if the undocumented family member were to face deportation. And I'm gonna talk about those three separately. So for the persecution-based relief, this is probably the one that you're, that you hear most about, which is asylum. And it is probably the most common type of evaluation that it's done in immigration court. An individual can be granted asylum if he or she, this is the language in the law, is present in the United States and otherwise meets the definition of a refugee. And the definition of a refugee is any person who is outside any country of such person's nationality and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a general particular group, or political opinion. And I highlighted in red well-founded fear of persecution because that is really the psycholegal issue that is relevant when you are conducting these types of evaluations. I also want to mention that just like in criminal court, for example, whether someone is eligible for asylum is up to the legal decision maker. It's an ultimate legal issue. I don't think that we should be commenting on that. I sometimes see some evaluations where the psychologist or mental health professional forms an opinion about that. And I even find it personally even more important in immigration court that we don't comment on the ultimate legal issue because it is so complicated, and the psychological evidence is just one part of the eligibility for asylum, right? The judge is taking into consideration a number of other factors. So we should only really be commenting on the psycholegal part of it. And so if you break it down, Persecution is defined as a threat to life or freedom, and it is considered an extreme concept that differs, for example, from general discrimination against minority groups. So it's something sort of really severe that must have happened that led the person to leave their country of origin. And the well-founded fear, there are actually two ways of proving well-founded fear. One is that, I'm going to start with the second one, that the individual, there is enough evidence that the individual experienced past persecution that is of such severity that it will be inhumane to be forced to return. So that the judge has enough evidence, and this typically involves some physical medical evidence, that the person was tortured in such a way or suffered persecution in such a way, like several members of their families were murdered, for example, that any other person will be afraid of returning, and it will be inhumane to force that person to return, even if you don't even touch on the fear of future persecution. For the most part, the judge is going to require some evidence of fear of future persecution, because in most cases, at least in most cases that I get involved, and based on, again, very little research on this, but based on what the lawyers tell me, in most cases, there is no physical evidence of the persecution or torture. So psychological evidence is the only thing that the lawyers can use. And here, of course, you can't fully attest to the veracity of what the person tells you that happened, but you can attest to whether the symptoms that they are reporting are symptoms that are, congruent or bona fide symptoms, or symptoms that you will commonly see in people who have suffered from genuine traumatic experiences. And so I also want to say that most people believe you absolutely need a diagnosis of PTSD to be able to support an asylum application. I mean, lawyers will push you to make the diagnosis, but I had found that that is not necessary. I mean, it's good to have it. It's helpful if you have enough evidence of it, but sometimes you might have individuals who don't meet full criteria. Also, of course, the cross-cultural assessment of PTSD is complicated, but if you can mention how the traumatic experience led to symptoms that are causing functional impairment, that have led to some successful asylum applications in my experience. Okay, another part of persecution is the Convention Against Torture, and is the CAT application. And this is the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, which the US is a signatory, prohibits the return of an individual to a place where they are likely to be tortured. And torture is defined as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person. Again, like here, you're really doing almost exactly the same thing as you're doing on asylum, where it's psychological evidence of trauma. The only differences are on the standard of proof. So there is a higher standard of proof for a CAT application, where you need to prove that the person suffered torture more likely than not, as opposed to 10%, which is the standard of proof for asylum application. And it might be available to immigrants with aggravated felony convictions, which asylum is not available for those individuals. I think, as with any other forensic evaluations, but maybe more even so with immigration evaluations, it's so important that you have a conversation with the attorney, and that you get educated by the attorney about all of this, and about exactly what's the application that they are pursuing, that they are clear on the referral question, because some immigration attorneys who don't have experience working with mental health professionals don't know how to guide you through the work. So you might need to help them guide you through and answer the questions that you need answered, so that you can really focus your evaluation. This is, another different type of applications, which are applications that are available to individuals who have been victims of a crime. And the U visa is for individuals who have victims of any crime, and these are undocumented individuals who have been victims of a crime by a citizen or a permanent legal resident, like a green card holder. And the victims of these crimes sometimes they have to prove that they've suffered substantial mental or physical abuse as a result of the crime, and they have to be willing to assist law enforcement and the government officials in the investigation or prosecution of the criminal activity. And this is significant because sometimes, just participating and helping the government in the investigation to be able to arrest the perpetrator can be traumatizing by itself, but it is a requirement if they want to be eligible for these types of evaluations. So these evaluations are very similar to what you will do in civil law, to a psychological injury or psychological harm type of evaluation that you will do in civil court. I mean, it has some perhaps more nuance that I don't have time to get into right now, but just to give you a sense. And then for U visas, as I said, are available for people who've been victims of any crime, and T visas specifically for people who have been victims of human trafficking. And then the Violence Against Women Act also allows immigrant victims of domestic violence, child abuse, or elder abuse to self-petition for permanent resident status without the cooperation of an abusive spouse, parent or child who is either a citizen or a permanent resident. And so here I am highlighting in red what are the psycholegal issues, because in addition to proving abuse, the immigrant has to prove that they've suffered extreme cruelty, which again, the psychological evidence here will be any evidence of trauma resulting from the extreme cruelty, that they engage in a good faith marriage, and that they have good moral character, as I mentioned before. So if they have committed any crimes, even if they are crimes that are minor, contextualizing that can be an important part of these evaluations. And then finally, hardship evaluations. These evaluations are really interesting. I find them really time consuming because these hardship evaluations involve, so there is a qualifying relative, a member of the applicant's immediate family who is a citizen or permanent resident. You need to prove that they will suffer extreme hardship if the applicant were to be removed from the United States, or if the whole family had to move overseas in order to be together. So it really focuses on the US citizen. So your evaluation is not on the immigrant that it's applying to avoid deportation, but on the US citizen or permanent resident and not the applicant. So just to give you an example, you may have a father who is facing deportation. Maybe he is a green card holder, but had a prior conviction. So now he's facing deportation, or he never had legal status in the United States, but he's been here long enough that he's gotten married, he has children, and the children are citizens. So if the court can prove, or the applicant can prove, that their children will face hardship if the father were to be deported, then they can avoid deportation. And so the evaluation is really documenting the hardship on the family members who have to be US citizens or permanent residents. If the kids are not documented, then they're not eligible for this. Very quickly, I want to mention credibility, because credibility, even though it's not an application per se or a form of relief per se, but it comes up in almost every single type of immigration evaluation. It's really at the core of immigration forensic mental health assessments. So for example, in asylum, it mentions that there needs to be credible evidence of the persecution. And the courts, immigration judges, often use inconsistencies in the immigrant's self-report as evidence of non-credible findings. They almost rely on this idea, as I include here from this author, that the truth does not change and that individuals must be able to recount experiences in detail. And so if an immigrant signs a declaration talking about the torture that they experienced, but then when they testify in court, they provide a date or a sequence of events that is slightly different from what they wrote in the declaration, the judge can find them non-credible. In fact, 40 to 77% of denied asylum claims include credibility as the reason. And I think this is really important because credibility, in my opinion, is an ultimate legal issue. We should not opine on whether someone is credible or not. It's really ultimately up to the judge, but we can educate the courts on, we can use a lot of the research on witness evidence that we can use. We can educate the courts on how individuals who've experienced trauma, might have memory recollection issues. And so I think that, the imperfection of memory, like we really can use our science to educate the judges on this, to help them make decisions about credibility. And then of course we can comment on symptom validity, exaggeration, malingering, as you should comment on most evaluation, or on all evaluations that are within the psycholegal context. Okay. So I cover, as I said, sort of 3 different types of applications that the 3 of them involve psychological evidence. As I said, there are a number of others that I didn't include here, but I want to move into competency now, because I find that is something that requires a lot of attention, needs a lot of psychological science to continue helping the immigration court system make decisions about this. And it's certainly something that is coming up more and more in my practice. I want to tell you just very briefly about this case. This is an immigration court case that was decided in 2011. I mean, some of you, if you're doing court in immigration court, would absolutely know about it. It's sort of like the Dasky of the immigration court. This was the first time that the courts really set some sort of a standard for competency in immigration court. And it came out of a respondent or an immigrant who was a native and citizen of Jamaica, who was admitted to the United States as a lawful permanent resident at the age of 10. DHS served notice to appear in court charging removal under section of law based upon his conviction of 2 or more crimes involving, something that weird language that then was amended to include controlled substance violation and drug trafficking. So he had been in the country for a number of years. He had been a lawful permanent resident for 10 years. And then suddenly DHS served notice to appear in court because they found that he had some prior convictions. And so at the first hearing before immigration court, he indicated that he had been diagnosed with schizophrenia and that he needed medication. At the second hearing, he indicated that he had a history of mental illness that was not being treated in detention. And at 5 other hearings, he indicated the same claim of mental illness and that he needed medication. And then at the next and final hearing, the respondent indicated that he could not represent himself. Now, again, reminder that most immigrants do not have an attorney or legal representation. And upon questioning by the immigration judge, he indicated that he believed he could answer questions put to him. Anyways, the short story is that while taking the mental illness history into consideration, the immigration court did not make an explicit finding regarding competency, and the respondent appealed, this time with an attorney, which led to the standard. And really, the issues that came up here were, when should immigration judges make competency determinations? What factors should immigration judges consider, and what procedures should they employ to make those determinations? I mean, remember, in criminal court, most of the time is the defense attorney that raises the issue of competency. So what happens when you don't have defense attorneys in most cases? Who is raising the issue of competency? I mean, obviously now this falls under the judge's responsibility in some ways. And so what type of education they need, when should they be bringing this up? And if they decide that someone is not competent to proceed with deportation court or with immigration court, what safeguards should immigration judges prescribe to ensure the proceedings are sufficiently fair when competency is not established? So Matter of Man is, established that the test for determining whether an alien is competent to participate is whether you're going to see is very similar to Dasky, whether he or she has a rational and factual understanding of the nature and object of the proceedings, can consult with an attorney or representative if there is one, and has a reasonable opportunity to examine and present evidence and cross-examine witnesses. This was huge progress, obviously, because the court finally set some language and a standard for it, but unfortunately, there was still no guidance for lawyers on when to identify immigrants who might be incompetent, what to do if they found someone, unable to really understand proceedings, what safeguards to put in place, how the evaluation will be conducted if there is no money to hire someone. And so a few years later, there was more progress that was being made. So in April of 2013, the EOIR announced what they called a nationwide policy to provide enhanced procedural protections to unrepresented detained aliens with serious disorders or convictions, and they call it phase 1. And unfortunately, I think we've all been waiting for a phase 2, and I think it might be they may be working on it, but this was, it's already been a long time, but they really published some guidelines that I thought were really helpful to assist judges on how to identify and determine issues of competency. And these are, you can Google it and find the guidelines, they're publicly available. And it really, it allows them to refer the immigrant for a mental health examination if the judge is unable to determine whether the respondent is competent, and then the court sort of appoint a mental health examiner to do this evaluation. The guidelines also establish what are the qualifications that are required to do these competency evaluations in immigration court. And this is something we don't have for any other type of evaluation in immigration court. There's no practice guidelines for this work. So, they established that they have to be licensed to practice psychology or medicine, have a specialized training, complete some approved training in conducting mental health examinations, and then able to document successful completion of approved continuing education in forensic assessment. And it also established, I'm running out of time, so I don't want to spend a lot of time on this, but it established sort of a new standard. Now, the EOIR guidelines assume that the person does not have representation. So it's really a standard on how the individual competency to represent him or herself, which leaves this unknown area on what happens if the individual actually does have legal representation, whether you follow these standards or instead, as some lawyers have been recommending that I follow the MAM standards because they include the possibility that the individual might have legal representation. So, you can read here the standards. So they are, considered incompetent if they are unable because of mental disorder to perform any of the functions listed in the definition of competence to represent oneself, which I will show to you in the next slide. And then they have a definition of mental disorder, which is pretty standard. So this is what they mention, and this, I wish I had time, but I don't, but it is really important to break it down because it sounds like it makes sense, but you really have to apply this to the context of immigration court and not to criminal court, which is what all of us who've been doing competency evaluations are used to. But again, it's similar to what you will do in criminal court, except that the system is completely different. So rational and factual understanding of the nature and object of the proceedings, allegation and charges, which is really the reason why they're facing deportation, roles of participants in the proceedings. For example, I would say that the vast majority of immigrants I evaluate do not understand the adversarial nature of the process, do not know who the government attorney is, do not know that there is an equivalent to a prosecutor in court. They see people sitting in court, but don't understand that there is a lawyer that is finding evidence to deport them. There's just so much lack of knowledge. Which of course that doesn't mean that doesn't make them incompetent, but it's information that you need to be aware of so that you can educate them and see if they can learn the information. The right to present, examine, and object to evidence, and then responding sufficient ability to make decisions about asserting and waiving rights, et cetera, et cetera. I won't read everything right now. As I said, this is all available online, so you can just Google EOIR competency guidelines or 2013, and you'll find it easily. So I'm running out of time. This obviously deserves a totally separate talk, but incredibly important to be culturally competent. And I know in some ways that has become a buzzword, but it is really crucial in immigration court. There are more than 276 different languages spoken in immigration court. If you work in this environment, you're going to be working with a vast, a really diverse cultural group. And so it is really crucial that forensic mental health assessments in immigration court are culturally valid. And this requires both training and didactic training, clinical supervision, and self-reflection, ongoing self-reflection on what might be your biases that you're bringing to the evaluation. And then it's just really important also to be knowledgeable about the different ways in which trauma can manifest across cultures. Of course, one of the most difficult parts of this work is, as I mentioned before, symptom validity and the malingering of trauma-related symptoms. I think that this is something we need more research on in general, and specifically when you're working with individuals who don't speak the same language or are from a different culture. And so, and just to end, I wanted to just go through there are more areas that I think are important for future research and future practice, but I wanted to just point some of them out there that I think are really important. And I really hope that if there are students listening today, or even practitioners who are listening today, that more and more people get involved in doing this work, because it's hugely needed. There is so much research that is needed to inform this work. There's so much opportunity. I also find it really interesting personally, and as I said, it's really needed. So I think we need to better define psycholegal issues in immigration court and understand what are the current practices. I've started to review some manuscript for journals where people are starting to do this. So surveying individuals who are working in immigration court to see what are their practices. And I think this is really incredible, and it makes me very happy. I think we need a lot more of that. We need to, as I said, the psycholegal issues are relatively well defined for competency because of those guidelines that I reviewed, which, by the way, that has only been implemented in a few states. So if you're in a state like New York, for example, has not implemented those guidelines, so courts are not appointing mental health professionals to do competency evaluations. So if you live in a state where that has not been implemented, you probably were thinking, I've never heard of these before. And that's probably because your state has not implemented the guidelines. I think that, it's gonna expand, but it's been a little disappointing the pace at which it has actually expanded across states. Sorry, I just sort of went on a different tangent, but so I think that there is some good definitions of competency because of those guidelines, but we need to do the same for other psycholegal issues, for hardship, for asylum, for victim-based evaluations. We need to really define psycholegal issues better, and we need to understand what are the current practices. We need more research on the cross-cultural validity of existing clinical assessment and forensically relevant instruments, particularly for trauma and malingering in general, but also specifically malingering of trauma-related symptoms. We need to develop forensic assessment instruments to assess specific immigration legal constructs like competency for removal, for example. And then I think it will be incredibly helpful to do more research into memory of accounts of persecution in the context of ongoing trauma, so that we can better assist the court in making decisions about credibility. And as I said, I could talk about this for a lot longer and tell you about a lot of other areas that I think require more research and more people to get involved with, but I'm gonna stop here. I thank you so much for your attention. I really hope that this was helpful, and I am happy to stay a few minutes longer if anyone has any questions. Thank you so much.
Thank you so much. This was such an interesting talk, and a topic that just much needed. We don't hear a lot about that, I feel like, these days. So thank you. And we do have a ton of questions, which means everybody is really engaged and interested in what you had to say. Do you have recommendations for specific symptom validity tests, those that might be more culturally robust for use in these types of evaluations?
That's such a good question. I'm going to say that I don't, and I know that's a very disappointing answer, but I am hesitant to recommend any specific tool because I don't think that any of them have been properly validated, specifically trauma-related symptoms. I can tell you a little bit what I tend to do, which is very imperfect, right? And I do talk about it in my reports, sort of what the limitations of that are. But sometimes what I will do is assess, do a structured interview, maybe even use some instruments, some psychometric instruments to assess for trauma, and then use an instrument that, for example, with a Spanish-speaking individual, use an MMPI that I think has proper, validation research, and then look at the validity scales and then comment a little bit on that, in my report. But I am hesitant, and again, I know that's it's a disappointing answer, but I'm hesitant to recommend one specific instrument that I think is the best for exaggeration of trauma-related symptoms, because I don't think any of them have proper, I don't think there's proper research on any specific one of them to the point that I feel comfortable recommending. Again, it's a huge area of research.
The same goes for, I guess, test measures in general. For specifically, I have someone here asking about what tests you administer for Spanish-speaking individuals, for example. But are there more culturally relevant tests that you use or that you think are out there, or how do you approach testing in this circumstance?
Yeah, so that you're always sort of weighing the pros and cons of doing testing in these evaluations. And I will say that sometimes if, Spanish, in some ways, we are lucky that there is more out there in Spanish than in other languages. But if you are, I just did an evaluation for someone who spoke Garifuna, which is a dialect, in El Salvador, like it's a dialect, and his Spanish was really terrible. There was no way I could use any testing, right, for that evaluation. So sometimes you're not using testing and then just acknowledging the limitations of that. And for Spanish speaking specifically, I'll say that the test that I use the MMPI as the Spanish MMPI. I have sometimes used let me just say, the MMPI, I also use for intellectual disability, depending on where the individual is from. For example, for people who are from Mexico, there is a ways that has been validated in Mexico. I use AY if they are from Puerto Rico. So it also depends on what country they are from. And then I use the TOM, I will mention that also as, there's some cross-cultural validity research, as you might know, on that. And I will say the trauma symptom inventory, although I'm not fully comfortable recommending it, but there is some research on the cross-cultural validity, even on the validity scale. So, I mean, there's some of it, just not enough that I feel comfortable recommending. So again, I never give fully satisfying answers because I think that there is just such a lack of, but I would say that what I do is I just balance. I also take into consideration acculturation. So some immigrants have been in the United States for a very long period of time, and they might even be fluent in English. And in those cases, then I feel much more comfortable using testing. I might feel more comfortable using testing that has been validated. Some tests have been validated in Spain, which is culturally very different. But if they're fully acculturated to the United States, I might feel more comfortable using that. So it really depends on acculturation, on the country of origin, on fluency, on level of education. And then I just sort of consider what are the pros and cons and how much do I need testing to answer the psycholegal issue. And I always mention it if I am not able to use tests because of the lack of proper testing, I mention it in my report as a limitation.
So another question I'm seeing pop up, individuals, especially in private practice, are struggling because they want to do these evals, but there's not a lot of funding available. And so they end up having to do them pro bono. And, we know that we need more people to do these evaluations. There's, a huge backlog, yet there's no money in this. Mm-hmm. Do you know of funding sources or ways for clinicians to be appropriately compensated to do this work?
I mean, unfortunately, I'm so my work is very limited to New York State. So I think if someone is in New York State, my advice is to get in touch with the public defender offices. And that might be the same in other states. As I said, there is now funding for individuals who have been found incompetent or where there is suspected competency issues. And so reaching out to the defender agencies. So for example, in New York, it will be the Legal Aid Society, Brooklyn Defenders, Bronx Defenders, because they are now starting to receive funding, pockets of funding to represent detained immigrants. And they are frequently looking for experts. I mean, I would say that I don't do all of my work pro bono. I do some of it pro bono, but even the work that I do that it's not pro bono, I don't get compensated as well as I get compensated for my work in criminal court. I mean, I think that's just part of the reality of this work, is that the funding is not there. I think it might start, I mean, again, there are more and more people getting involved, and I think there is more and more awareness of how crucial our work is to these findings. That's why we also need to do more research. So, research on how actually having an expert can increase the chances is important for the advocates to advocate for more funding for this. And so, but yeah, unfortunately, it is tough, because it is true that the funding is not there, and often you just end up doing the work pro bono or for just low fee or like flat fee sometimes that they ask me to do that. Like no matter how much work I end up putting, which might be a tremendous amount, you're capped at like a very low level. So
do you have recommendations? Oh, before that, people are asking if you put your contact information back up. So yes. I don't know, did you have it on one of the slides?
It is in my last slide. I thought it was showing. It's not. Okay, so it's V as in Virginia, Barber, BARBER at NYU.edu. It was on the last slide.
Perfect. Okay, so what are your recommendations for trainings or reading to develop appropriate competencies to do these types of evals?
Okay, so I think that, again, because I think that there are, let me say, for someone who there's sort of three different areas of competency, right, that you will need. So, and of course, it depends on what competency you already have. So, but I will say that one is cultural competency and any trainings that you can get on trauma related about how to assess trauma and how to assess trauma cross-culturally. For the forensic piece and to really get an overview of the immigration legal system, the psycho-legal issues involved, and then more specifically the forensic, the sort of forensic component of this, I can recommend the book by Evans and Haas that it's called Forensic Psychological Assessment in Immigration Court. It was published in 2018. It's a little book. I think it's great. I have found it very helpful. There's another book that was just published, I think recently. It's called Conducting Immigration Evaluations. I have not read it yet, so but I read the content and it seemed really relevant. Forgive me if this is a little bit of sort of self-publicity, but I am publishing my own with, and I want to say my co-authors are cross-cultural psychologist, and an immigration attorney. So it has sort of the three different areas of expertise, I think, well covered in the book. And the immigration attorney, I think, did a really good job in covering the legal part of it in a way that it's understandable to the non-legal professional. There is a workshop in concept that it's a one day long, that it's about immigration evaluation, about forensic evaluations in immigration court. And there are now some, as I said, I'm starting to see more and more sort of peer review articles on it that I had found myself really helpful. But I think a good place to start is, I would say any of those three books are the first, to my knowledge, the first three books that cover these specifically.
So next question is, the Human Rights Watch has offered an estimate that 15% of detainees have a mental illness. Would you agree with that? And do you think they're including PTSD in that estimate?
So I think it's probably way higher than that. And I'll tell you why I'm thinking that. I also, now that you mentioned the Human Rights Watch, they do have some really good resources in their websites, by the way, on how, or for but only specifically for asylum evaluations for mental health professionals. So that's another good place to go if you're doing specifically an asylum evaluation, a good place to get resources. So I think the number has to be much higher. And the reason why I think that is because if you look at 15% is the estimated number of people with serious mental illness in jails, in the criminal system, right, across the country. That's serious mental illness. Just any mental illness, it's more, it's like almost half of people who are incarcerated in jails have reported, some mental health symptoms. And so when you're thinking about immigration detention, now a group of individuals that are already really vulnerable because of all of the reasons that I mentioned before, who are being detained without legal representation, without understanding the system, without speaking the language, right? I think that 15% might reflect serious mental illness, but it doesn't reflect any mental health symptom. And I certainly don't think it reflects or it includes or accounts for PTSD or trauma-related disorders. But again, we don't know for sure.
And do you know if detained individuals have any right at all to medical or mental health care? And do you know about the source of that right?
Yeah, they have this. Once you are in any detention center or jail or prison, you do have a constitutional right to, I forgot I should know that because I work in a jail, what's the Supreme Court case that, but you have a constitutional right to receive mental health and medical services, but the threat, the bar is really low, right? And sort of they, in my experience in some detention facilities, they do get an intake. So they get some questions that are asked when they intake into the detention facility. But then I've seen cases of people with very serious mental illness who are not receiving medication or who are only receiving medication but are not seeing a counselor. So there is no, it's a very low bar. And then there was a jail at, actually there is an interesting case in Orange County Jail in New Jersey that detains immigrants that was sued for not providing any reentry services. So now there is a court case coming out of that it's providing some minimum standards for reentry services for immigrants. So cases are starting to pop up, as I said, because of lawsuits. But so yes, the short answer is that they do have a constitutional right in theory, just like anyone who is in any detention facility. But it's a really low bar. And especially the ICE-run facilities, in my experience, are pretty poor. And other facilities that might have experience detaining individuals as part of their criminal court that are already providing services and then subcontract some of their beds to ICE might just extrapolate the same services, so they might be decent. But an ICE facility that only detains immigrants, again, I don't have hard data for this, this is just my opinion and just what I've seen. they tend to provide pretty poor standard, but pretty poor services.
Next question is, how should mental health professionals handle report writing for cases in which an individual seeks a mental health evaluation for immigration court proceedings, like asylum, yet the individual is resilient and psychologically well-adjusted or not experiencing any mental health symptoms?
Well, I mean, I think, again, just you have to write in the report if the person in that case, that person might not meet the criteria for asylum, that it's ultimately up to the judge to decide, right? So you can, I mean, immigrants are, I talked about sort of how they're vulnerable to mental illness. They're also incredibly resilient, right? And so you see people who go through unbelievable trauma and don't experience any trauma-related symptoms. I think in the report, it is important to just talk about what you've, include the data that you were able to collect, that use collateral sources of information, and explain. There might still be psychological evidence of trauma. It might just not be to the extent, as I said before, that meets full criteria for PTSD, and you just want to explain that. But if there is just no evidence of trauma whatsoever, then you don't have psychological evidence of trauma. And then the lawyer is going to have to use other evidence for the asylum application. If the evidence is not there, it's not there. But if you think that it's not there because they're using some, it's manifesting in different ways, it's not manifesting in the most obvious ways, it's not being captured by the testing for whatever reason, then that needs to be explained in the report.
All right, we're 15 minutes after. I feel like we could go on for hours. This topic is so interesting and important. Thank you very much for your time. We're already getting comments that people would love to have you back. So you'll be hearing from me, but really, really grateful for your time today. Thank you.
Thank you. I really appreciate it. Thank you for your attention, everyone.
Yeah. All right, everyone, we'll be emailing you the CE link. So stay tuned for that, and we will see you all next week. Thank you again.